All right, let's start. Hello, everyone. My name is Alexandra Bochnakova, and I'm the president of the Washington Foreign Law Society. And I'm very happy to welcome you today for such a great panel with Amanda, Mark, Craig, and last but not least, our co-chair of programs, Momin. The Washington Foreign Law Society is a non-profit organization, educational organization that exists since 1952 and is working on promoting international law, knowledge of foreign law, comparative law, and international issues. If you don't know the Washington Foreign Law Society, or if you're not a member yet, I would encourage you to go on the website and register and become a member. You will then receive our newsletter. We have very, very interesting events in the pipes. We have our usual annual gala coming on October 16th. We just got the confirmation today with a very prominent guest, Director General Rafael Grossi from the International Nuclear Agency Organization from Vienna. We would continue our artificial intelligence series. And of course, we're going to prepare other events on a monthly basis or bi-monthly basis. We hope to be able to host again Embassy Roundtable in December in one of the embassies in Washington, D.C. And next year, our usual gala co-hosted with the US State Department honoring a country. All this is in the cooking. Stay posted, visit our website, and we hope to see you there again. Thank you so much for joining us today. And I want to thank again our panelists for your time and for sharing your insight. I'm very excited for this conversation, and I'm going to give the floor to Momin. Thank you, guys.
Thank you so much, Alexandra. Well, it is a pleasure to welcome all of you to our panel titled Not So Neutral, the Drama of Arbitrated Challenges. It's a bit of a provocative title, but rightly so, because we're diving into what happens when the person meant to be impartial might not be impartial after all. We will be talking about the ethics, the strategy, and yes, the drama that can come with challenging an arbitrator. Just a quick reminder, you can submit questions to our panelists by clicking the Q&A feature at the bottom of your screens. And with that, I am really honored to introduce the panel that we have with us. First up, we have Amanda. Amanda is counsel at Covington and Burling, where she advises both companies and sovereign states in complex international disputes. She has been involved in the recognition and enforcement of arbitral awards in US courts and regularly advises on international trade and investment issues. On top of that, she teaches international law at George Washington University and maintains an active pro bono practice in immigration and human rights law. She was also recently named one of Law 360's 2025 Rising Stars in International Arbitration. We also have with us Craig Gaber. Craig is a partner at Continental PLLC, and his practice deals with legal issues that cross international borders. He has worked with sovereign states, Fortune 500 companies, and investors across a wide range of sectors, including energy, mining, and tech. He also teaches as an adjunct professor at William & Mary Law School. And finally, we have Mark Kantor. Mark is an international arbitrator and a mediator with extensive experience in commercial and investment disputes. He serves as an adjunct professor at Georgetown Law and is editor-in-chief of Transnational Dispute Management. A former partner at Milbank, Mark has held roles on the World Bank Group Sanctions Board, the AAA Board, and numerous editorial and advisory boards. He is a chartered arbitrator and the author of the award-winning book titled Valuation for Arbitration. So my first question for Amanda and Craig, from your experience as counsel, what are some of the most common grounds you consider when deciding whether to challenge an arbitrator? And what key factors do you weigh before moving forward with the challenge itself?
Amanda, why don't you begin?
Sure. Thank you, Craig, and thank you, Momin, for organizing the panel and for the kind introduction. So at the outset, this is a sort of quintessential question that counsel have to deal with all the time. I think I would say, in the first instance, it applies equally to an offensive and to a defensive posture, right? So as counsel, you're considering whether to potentially challenge an arbitrator. And usually, oftentimes, even before that, you might be advising your client on appointing an arbitrator and whether a given candidate could survive a potential challenge if you think they're vulnerable to one. In terms of the most common grounds that arise, I think independence and impartiality has been far and away the most common issue that sort of comes up in these circumstances. And, in addition to looking to the sort of specific facts and circumstances that arise in that context and whether there are, comparable or relevant standards that you can look to in the IBA guidelines or other publicly available challenge decisions. I think the number one question is who decides, right? So who's going to be deciding this arbitrator challenge? Is it going to be the other members of the tribunal? Is it an appointing authority? Do you have an appointing authority? Do you know who it is? Would you have to get one? And so all of this really feeds into the strategic considerations from the counsel's perspective.
Well, let me say first, thank you, Momin, Alexandra. Thank you, Washington Foreign Law Society, for inviting me to join this panel today. I endorse everything Amanda just said, agree completely, and I would recast it by looking at through three different lenses. So first, when considering to bring a challenge, I'd look first at the substantive grounds. So what is the nature of the issue giving rise to the potential challenge? And agree with Amanda, this could be a matter of independence, impartiality. It could be a so-called issue conflict, which we might get into later in the discussion. But where does this particular issue fit into all of the mandatory or discretionary guidelines that might guide the adjudicator? So I would look at the IBA guidelines, how to slot it into any of the different colored lists that they give. I might look at the new code of conduct for arbitrators in international investment disputes, which is new and I assume being applied in greater frequency, and any other applicable standards that might apply. Less common, but still possible, are any relevant requirements set forth in the bilateral, multilateral investment treaties. Traditionally, they did not get into any particular requirements for independence and impartiality, but more recently, those requirements have been inserted into treaty texts. So I popped onto the UNCTAD database just to find an example. And in fact, the most recent one that I encountered had particular requirements. So quoting from the European Free Trade Association's Economic Partnership Agreement with Malaysia, they require that potential arbitrators be independent and impartial, including serving in their individual capacities, and not be affiliated with, neither take instructions for any party to the dispute, nor have dealt with the case in any capacity. So we might see that newer treaties that are being drafted now are coming to force, put explicit requirements of independence or impartiality onto potential arbitrators where none have existed in the past. And then finally, Amanda also noted case law, very important. How has this issue been treated by similar tribunals, which of course will let us know how it might play out in our case. Secondly, I'll look at it through an evidentiary lens. How likely am I to prevail? What do I need to show? What documents or possibly testimony do I have to draw upon? Of course, in the usual circumstance, the challenged arbitrator will have an opportunity to furnish a response. And so what might I expect that response to say, and how would it play into the adjudication of the issue? I might look at whether a disclosure has been made. Is it a partial or incomplete disclosure, or did we uncover an issue that had not been disclosed at all? And what effect will that have on the decision? And then finally, I'll look at it through procedural lens. What effect will the challenge have on the arbitration as a whole? Do I want to slow down the proceeding? That is usually, but not always, the respondents. Pausing the proceeding to take time out to adjudicate an arbitrator challenge obviously will add to the overall length of the proceeding. Or do I want to keep things progressing at a normal clip, which is usually, but not always, the claimant's position? Is the challenged arbitrator a wing arbitrator, or is it the chair? And what effect will this have on the proceeding too? If I were to challenge the chair, will that tilt them away from me? And finally, if I succeed in my challenge, I'm not always guaranteed that the replacement will be more disposed to my position than the original person. And so all of those factors will go into deciding whether to make the challenge, which of course is a tactical decision that has to be made with reference to the particular circumstances.
Well, thank you so much. Mark, coming to you, drawing on your experience as an arbitrator, how do you personally approach situations where a challenge is brought against you? And does the risk of being challenged influence how you approach disclosures from the outset?
Momin, first, let me thank the Washington Foreign Law Society for organizing this program and for inviting me to participate in it. I'm grateful for the confidence that shows. And Momin, in particular, to you for putting the program together. I'd also like to thank you, Momin, for that very flattering introduction of me, which I wrote. The answer to your first question, how do I personally approach situations where a challenge is brought against me? I think I am not unusual among arbitrators in believing that the great majority of challenges are not at all well-founded. Instead, they're brought for tactical reasons. And that is frustrating and annoying. And I feel that emotionally. Will that have an impact when that challenge is dismissed on how I conduct myself in the arbitration? I strongly feel it does not, but I equally strongly feel that counsel and the party who brought a challenge that they knew was very weak have to have decided they wanted to take the risk that I would act negatively. If I'm the chair, that's a huge risk, as Craig just mentioned. If I'm a party-appointed wing arbitrator, the other party having appointed me, then they may start from a presumption that I have a preconception in favor of that party. That, in my case, I again strongly feel is not true. I believe in independence and impartiality and do not stray from that regardless of who appoints me. But I find a lot of parties and counsel do not think that's how arbitrators act. And unfortunately, there is some evidence in some parts of the arbitration world to support that feeling on their part. So I do react in my own mind poorly if I think the challenge is not well-founded. Your next question was, does the risk of being challenged influence how I approach my disclosures? No, not the risk of being challenged, but the risk of having the ultimate award vacated definitely does influence how I approach my disclosures. Going back into the mid-2000s, there was a series of federal court cases, appellate cases, Ninth Circuit, Fifth Circuit, Second Circuit, and I was following them very closely. I came away with the conclusion that about 2/3 of US federal court judges think about disclosure roughly the same way I do, but about 1/3 had a more rigorous view of what disclosure called for. From that time, I have always structured my disclosures as over disclosures to address that 1/3 of federal court judges, because I don't know what judge is going to be hearing an eventual confirmation or vacatur motion. And I want that judge to look at my disclosures and say, what is all this wasted information about? I would rather over-disclose, which I do quite heavily and have a bit of a reputation for doing that, than under-disclose. And that is definitely driven by the risk that an ultimate award might be vacated.
Thank you so much. Amanda and Craig, going off on what Mark just said, in your opinion, are some challenges used primarily as strategic tools, for example, to delay the proceedings or unsettle the tribunal? And does the timing of a challenge, whether early or late in the process, often reflect that fact?
Go ahead, Craig.
Sure. Well, I will cop out and say I think both things are true at once, Momin. I think it's undoubtedly true that parties do use challenges to control the pace of the proceeding, to slow it down, to gum up the works. At the same time, there are very real fairness issues that are implicated by challenging arbitrators. I think the ultimate concern of the tribunal and the parties is rendering an enforceable award, and to the extent that that might be jeopardized by having an untested conflict or challenge to independence or impartiality is very real. So it's absolutely the case that there are genuine challenges. It's absolutely the case that there are frivolous ones, and it might, have elements of both in any given circumstance. It's really ultimately about balancing the procedural fairness along with tactical considerations at the same time. It's also the case that declining to challenge an arbitrator where reasonable grounds may or may not exist is itself a tactic too. So a party ought to analyze the issue very carefully and think, looking at the guidelines, looking at case law. We have seen other parties challenge an arbitrator in these circumstances. It may or may not succeed, but ultimately we want to advance the case. We think the award will be enforceable ultimately, and therefore we're not going to exercise our right to challenge the arbitrator. So all these things kind of exist at the same time. And again, it's difficult to kind of tease out all the different strands, which is very much a case-by-case issue.
I agree fully with what Craig said. In terms of timing, I think it's a lot easier to sort of, presume that a challenge right at the outset is based on, the disclosures and the information that was sort of just revealed to the parties. And it's important that, before the proceeding really begins, all parties are informed fully about, the potential conflicts of interest and are able to sort of air those out. Later in the proceedings, I think what is really key there is what is the nature of the new circumstances that would merit a late in the game challenge, and when did they become known to the challenging party? And I think that's where, you might see challenges raised on sort of less than clearly meritorious grounds, or for example, based on certain adverse procedural decisions taken in the course of the arbitration, where it sort of just seems like, the party's trying to throw a wrench in the process because they don't really like how it's going for them.
Momin,
Well, thank you so much.
If I may grab the mic back too, I think it merits mentioning too, they're no longer as new, but the most recent ICSID rules revision specifically tightened up the amount of time to bring arbitrator challenges because they were seen as being abused in the past. So under the 2022 rules, now a party must challenge an arbitrator within 21 days of the constitution of the tribunal, or if the issue becomes known later in the proceeding, within 21 days of that period. And by kind of instituting this time period, it's a way that the ICSID as an institution, it's the way that tribunals can kind of fight back on the unmeritorious challenge by requiring parties to bring them in a timely manner. So certainly, the community has been discussing this for quite some time and have taken steps to kind of clamp down on just kind of mere gamemanship.
And Momin, if I could follow up on what Amanda and Craig have just said with a point of personal practice. In every arbitration in which my name is put forward, I make a disclosure about what I have not investigated, and that's based upon the Second Circuit Court of Appeals case colloquially called AIMCOR. And then I go on to say that any party who has reason to think that I may suffer from lack of impartiality or lack of independence should come forward with that. And for that purpose, they should undertake an investigation right at the beginning. And my view of that is that I want the parties on notice from the very beginning that they have a responsibility to investigate me at the beginning. If they do it at the beginning and come forward with a challenge, they're not going to delay things very much. But if they wait until it appears they're going to lose, for example, then, or they don't begin the investigation until quite late, that can indeed interfere with the timing and ultimate resolution of the arbitration. I try to mitigate that right up front in a standard set of sentences in every disclosure statement I put forward.
Oh, thank you so much. And I think this is the perfect segue to my next question. This conversation would be incomplete without talking about the decision in Rockhopper versus Italy. And just to provide some background, in this case, an ICSID ad hoc committee annulled a 2022 award on the grounds that the tribunal had been improperly constituted. Italy had argued that the claimant's appointed arbitrator had failed to disclose his involvement in criminal proceedings in Italy during the 1990s. Now, although the arbitrator had been acquitted, the committee found that his failure to disclose this information breached Article 14.1 of the ICSID Convention and Rule 6 of the 2006 ICSID arbitration rules, both of which require arbitrators to disclose any facts that would cast doubt on their independence or impartiality. The committee clarified that the duty of disclosure hinges on what the parties might reasonably consider relevant, and by withholding this information, the arbitrator had denied Italy the chance to raise an objection to his appointment and ultimately compromised the integrity of the proceedings. Now, while the committee did not question the arbitrator's moral character, it nonetheless concluded that the failure to disclose justified annulment under Article 52(1)(a), as the tribunal had not been properly constituted. So my question for the panel is this. After Rockhopper, should arbitrators now be disclosing everything from ancient parking fines to long-forgotten criminal convictions? And where should we draw the line between reasonable transparency and turning disclosure into a forensic background check? Amanda, do you want to start with that one?
Sure, I'm happy to. So I think the issue I see with Rockhopper sort of goes to what you're focusing on here, which is the duty of disclosure. And I think what's key and what has maybe gotten lost in the Rockhopper debate is that, the IBA guidelines make clear that the standard for whether to disclose and the standard for whether there's a conflict of interest are not the same, right? The standard for whether you must disclose is a subjective one, and the standard for whether there is an actual conflict of interest meriting disqualification is an objective one judged by a reasonable third party believing there are justifiable doubts. So, I think in Rockhopper, you could have envisioned an outcome where there would have been a duty to disclose that information, but that the information wouldn't have given rise to justifiable doubts as to independence or impartiality. And further, that maybe even a failure to disclose doesn't necessarily mean that a conflict of interest exists or that there should be a disqualification based on this objective third-party standard. So, I think there are other issues also involved in Rockhopper based on the point that Mark was going to about the burden on the parties to do a reasonable inquiry, and there the fact that it was Italy, the respondent state, that should have been able to sort of air out this potential conflict of interest much earlier in the proceedings. But sort of more broadly looking forward in terms of how we think about it, I think even if the standard of disclosure is sort of broadened to take account of this subjective standard that's recognized in the IBA guidelines, it's important that the two are not merged and that we're still judging the merits of disqualification based on an objective, reasonable third-party test.
Thank you. Mark or Greg?
Momin, the first part of your question, ancient parking fines and long forgotten criminal convictions, identifies two very different issues. One is the significance of the item that was not disclosed. And frankly, a criminal conviction is a heck of a lot more significant than a parking fine. And then the second is duration, ancient or long forgotten. Leaving to one side that I can't imagine myself ever forgetting a criminal conviction against me, even if it's later overturned. It was long ago. So too, the last parking fine I got. My personal practice is to ignore completely the timelines in the IBA rule guidelines, 3 years, 5 years in the ICSID guidelines, the like. I go back as far as I can recall, or as far as a documentary search available to me shows. And part of the reason for that is most of my arbitrations are seated in the United States. And the US courts do not pay attention to the 3-year, 5-year type time limits that are found in our best practices guides in the international arbitration community. So the duration point, I'm persuaded that we should not limit ourselves in time. If we think there's something out there that is likely to give rise to reasonable doubts about impartiality or independence, the fact that it occurred many years ago would not deter me from disclosing. With respect to significance, that's the second part of your question anyway, draw the line between reasonable transparency and a forensic background check. All I can say in that regard, of course, is first of all, whatever words we find in these guidelines are always capable of interpretation, and someone seeking to assert a challenge will interpret the words more rigorously than someone who's seeking to defend a challenge. But what I do see is over the years, there has been a gradual tightening of standards so that the way, speaking hypothetically, one of the grand old men of the 1960s or 70s might have approached a mandatory disclosure duty, and the way a coward like me discloses it today, dramatically different and driven to a considerable extent by an evolution in how institutions and courts have begun to more strictly police the disclosure obligation. So while I don't know that one could ever draw an arithmetic formula or a line, I do think that we are all being pushed towards greater disclosure, not lesser disclosure, and that should guide the arbitrators and investigating counsel in how we treat the arbitrator's disclosure obligation.
I thought I might add a little bit more color on the Rockhopper decision in particular to illustrate, one, the fairly unique circumstances that it raised, and two, kind of why it became such a big deal in the international arbitration community. So looking at the case kind of from an objective point of view, the annulment decision itself pointed out kind of how rare the circumstances are. So in the annulment decision, the ad hoc committee found that there had been 194 annulment proceedings within the ICSID regime. Only 16 of those 194 led to decisions in which improper constitution of the tribunal, which was the ground Rockhopper ruled on, had been raised as a ground at all. And only 3 of those 16 had facts that were said to show the arbitrator's lack of qualification arising the first time in the annulment proceeding, as opposed to being raised in the plenary proceeding. And only one time before the Rockhopper case in Iser versus Kingdom of Spain had this actually succeeded. So right now you're looking at the second case or second instance out of 194 total. So a very kind of rare circumstance. Secondly, and more subjectively, there were fairly unique aspects within the Rockhopper case itself. So as Mark correctly pointed out, the charges themselves go to an arbitrator's character integrity. So the charges concerned alleged falsification of documentary evidence and aiding, abetting perjury in a domestic criminal proceeding. So unlike a parking ticket per se, or unlike, to give another example, these go directly to the qualities that an arbitrator is supposed to evince. Secondly, it was a prosecution by the host state in the arbitration. So if we think, had there been a prosecution in a third state, not the host state, not the home state, not the state of the arbitrator's nationality, would it have been such a big deal? Third, there's this really kind of technical issue under domestic law as to whether the conviction was completely expunged or not. So what we saw from the decision was there had been a conviction, it was affirmed on appeal, it was then tossed out on basically the equivalent of statute of limitation grounds, such that it never existed in the first instance. And that is probably what led the individual in question, or I shouldn't speculate, but that might have been why he chose not to disclose it, because it is as though it never existed in the first instance. And finally, the timing, something that Amanda and Mark both spoke about in our earlier discussion. This was not known to the respondent until after the plenary proceeding had closed. It could only be raised in the annulment proceedings, which, as I said a moment ago, is a very rare circumstance. So it's almost like the perfect storm of an arbitrator challenge on these grounds. But it's also a helpful reminder that these are both bugs and features of international arbitration. One of the key features is that the parties have the ability to choose who decides their dispute for many different reasons. You get the benefits of intellect, education, experience, commercial sensitivity, but you also want to take advantage of circumstances that the arbitrators faced before. And when those qualities come to a head, you might get a circumstance like this that really kind of makes for a vexing decision. Certainly, deciding to annul the award on this ground is significant. I know that Rockhopper has announced that they're going to bring a new claim, and the expense, the time, the questions of justice involved with that is very significant. So I don't want to lose sight of the fact that this is a very complicated and important decision, irrespective of how it came out.
Oh, thank you so much. Craig, just sticking with you because you've recently written a chapter on this, but could you help us by explaining what exactly we mean by issue conflict? Now, this seems especially relevant now, given that so many arbitrators and people in the community are academics, speakers, writers, and perhaps even avid social media users.
Sure. So in our discussion so far, we've used the terms independence and impartiality, which are the two real touchstones for arbitrator qualifications. There is potentially a third, which we call issue conflict, and it's really subject to characterization. as to whether this is something different or whether it's kind of a subset of independence and impartiality. But generally speaking, when we refer to independence, we mean the existence or not of any sort of external control over the arbitrator herself. When we talk about impartiality, we generally refer to whether the arbitrator has any relationship or disposition toward either the parties or the parties' counsel. And so we might draw a distinction with issue conflict being somewhat different. So there have been several different definitions offered in the academic literature, but generally speaking, it refers to an arbitrator's relationship with or predisposition toward ideas or issues or how the law ought to operate, as distinct from a relationship with the counsel or the party. And so the idea that arbitrators must come to a dispute with an open mind, of course, is very important. But they're not, we're not expecting them to kind of shed all of their extensive academic or practical commercial experience. So they're bringing all that to the dispute. That's the value that they bring, and presumably why they were selected to arbitrate this particular dispute. But if we wish to avoid issue conflicts, that also raises a lot of different questions. So if there's an issue in the current dispute that an arbitrator has spoken on in the past, how central must that issue be before it becomes disqualifying? Do matters of fact, for example, a set of government measures that affect an entire class of foreign investors, does that give rise to the same concerns as matters of law, such as the scope of a substantive standard of protection? The challenge is that we work in a field of ideas, and we want our arbitrators to have experience. We want them to be engaged in academic and important issues to the community. And the international arbitration community benefits when knowledgeable interlocutors engage with these issues. But there's a very fine line that ought not to be crossed into prejudgment. That's something we want to avoid, and I think it can become very difficult to determine where that line is between an arbitrator that's engaged with the issues and an arbitrator that brings prejudgment into a new proceeding.
All right, thank you so much. Mark, does the threat of removal for issue conflict create a chilling effect on legitimate academic and professional engagement, or is this an acceptable price to pay?
I think that the bigger chilling effect moment is on the potential for arbitration appointments and for counsel engagements. I don't know that you have to get to the question of whether it might result in a challenge to an arbitrator and potentially removal or vacatur of an award. I suspect many of the people who are listening to this are familiar with a discussion list, an email discussion list called OGMIT, which I've been an active participant in, and it's under the umbrella of transnational dispute management, of which I am the editor-in-chief. When Thomas Walde started OGMIT in the late 1990s and early 2000s, there was very active participation by counsel and arbitrators in conversations that were protected on the listserv. Over the years, though, those people have often become just lurkers because they've realized that what they said on the listserv could rebound against them, either in getting appointments if they were arbitrators, or getting engagements if they were counsel, or notwithstanding Chatham House rule, being tossed in front of them in an arbitration. Excuse me. So I'm not sure the threat of removal for issue conflict is what creates the chilling effect. I think it's the business consequences that is the chilling effect.
Thank you. Amanda, do you have any thoughts?
Yeah, I would just to add to what Mark said, I think in my experience, having interviewed arbitrator candidates for particular cases, we do hear from arbitrators themselves that they intentionally choose not to be, that active on social media or listservs or certain types of, making public statements because of this risk, whether it's, the risk of not being appointed at all or the risk of losing a potential appointment to a challenge. So I do think it's affecting behavior for arbitrators and counsel. We see that.
Understood. Thank you so much. We have a few questions from our audience that were pre-submitted. So I'm just going to pose those questions and anyone can jump in. So the first question is, are there any particular jurisdictions where you have noticed significant cultural differences being used to justify an arbitrated challenge, or where such differences have made it more likely for a challenge to succeed or fail?
So, Momin, the obvious answer is Russia, where the Russians now have a list of countries they consider not to be friendly, and arbitrators who come from those countries, the Russians look very askance at those arbitrators and will not, in their national courts, give effect to awards in which those arbitrators participate. But apart from outliers like Russia, I think it's fair to say that there are some jurisdictions that are erratic and other jurisdictions that are more predictable. And I'm not going to name countries. And then there's a third category of jurisdictions which simply play the home court. And if the decision is adverse to the party who is based in that home jurisdiction, then the courts in that jurisdiction will look favorably upon any excuse to avoid giving effect to the award, including a challenge to the arbitrator. That's not at all comfortable, but it's the price of living in an international world where we don't have a single dominant institution that decides everything. Instead, it's all left to individual countries.
Thank you. Greg, do you have any thoughts?
I don't know if I could improve upon Mark's analysis. No.
Amanda?
Yeah, I agree with everything Mark said. I think, I have some concerns about the extent to which we see arbitrators being sort of automatically associated with the policies of their nationality, right? So, the US government can take any number of foreign policy measures that a US national may or may not agree with, right? But the sort of Russia model that Mark is describing basically tends to assume that certain arbitrators coming from certain countries, their views must be aligned with whatever policies are being taken by the government that's in power at the time. And I think that's a concern and sort of an overreach.
Right. Thank you so much. Our second question is, given your experiences with both commercial and investment disputes, do challenges to party-appointed arbitrators differ in tone or outcome between these settings? In investor-state arbitration specifically, do you think the increasing frequency of arbitrated challenges reflects a deeper legitimacy crisis, or is this a healthy sign of procedural rigor?
I'll take a stab at it, Momin. I think you could look at the issue from both a quantity and quality perspective. So in terms of quantity, commercial arbitration is much more high volume. There's simply a lot more cases, a lot more parties, a lot more arbitrators than there are in investment treaty arbitration, and therefore a much greater potential for alleged conflicts. I don't know that there's a difference in tone, but that might suggest the second distinction, which is one of quality. So in the Rockhopper annulment decision, the ad hoc committee pointed out that treaty-based arbitrations have a public quality, and they suggest that therefore that requires a higher standard of independence or impartiality to be met than might be required in commercial arbitration. But because they have a public quality, because the measures at issue are government measures that regulate the economy and society, that also invites kind of sometimes invites a much more respectful is maybe not the right word, but a challenge that understands the gravity of the situation. And looking back at commercial arbitration, this is something that happens more often. The consequences of a challenge are not as high stakes, perhaps, as they are in treaty-based arbitrations. So again, I don't know if the tone or outcome necessarily is different, but there are just so much higher stakes involved in the treaty-based arbitrations that I think the decision to make a challenge and the decision ruling upon it carries much more weight with it.
Understood. Thank you so much. Amanda and Mart, do you have any thoughts?
Just to point out that I'm not sure it's correct to assume that there has been a dramatic increase in challenges in investor-state arbitration. ICSID maintains statistics on this for their own arbitrations, and the numbers do not seem to be rising radically. So I think there is much more attention to those challenges in the arbitration community. I'm not sure there are, in fact, that many more challenges. Obviously, there were very few challenges back a number of decades ago, but the world has moved on in arbitrator disclosure obligations across the entire arbitration community.
Understood. Thank you so much. Amanda, do you have any thoughts?
No, nothing major to add. Happy to move on.
Right. So we have a question in our Q&A feature, and it says, is it appropriate for a tribunal to award costs if a challenge is made to an arbitrator that is not made on merit? For example, a challenge based on university faculty membership of council and the proposed arbitrator, which is clearly green and not orange. Craig and Amanda, if you want to take a shot at that.
Sure. So, I mean, I can definitely say what I would argue as counsel on behalf of my client, which is that the tribunal should undoubtedly award costs in this kind of circumstance. I mean, I think this is the sort of, you know, if you really take it at face value, a paradigmatic case where you know, if it's covered by the green list, there's no obligation to disclose and there's no actual or apparent conflict of interest. So, you know, I would go even further and I would say the tribunal can award costs, and also we should think about whether there's an opportunity for some kind of summary disposition or dismissal of challenges that fall within this kind of sort of clearly non-meritorious category.
Thank you. Craig?
Yeah, nothing significant to add. No, I think it's very appropriate for a tribunal to take the relative merits of the challenge into account when apportioning costs.
Understood. Thank you so much. One other question that I had, and going back to issue conflict, given that instruments like the IBA guidelines only touch upon issue conflicts indirectly and offer limited guidance, do you think that there is a gap in the framework that exists right now? And would it help to have clear guidance or even a dedicated guideline on issue conflict?
I'll take a stab at that. Yes. So consider the case of the more recent code of conduct for arbitrators. Perhaps some of my fellow panelists or audience members are familiar with how that came together. But there, as with other guidelines, were several drafts that invited commentary from the community. And the very first draft of this code of conduct kind of touched upon issue conflict, by suggesting that prospective arbitrators ought to disclose speeches, academic writings, things of that nature. That got a lot of negative attention and eventually was taken out of the final code. So to the extent there's a gap in the framework, that might be by design, that might kind of reiterate the point that these issue conflicts are ambiguous in their very nature, that we want to encourage people to feel free to comment freely on issues that pertain to the international community. If one were to pull together, the equivalent of the IBA guidelines specifically for issue conflicts, I think it would involve a lot of very difficult trade-offs and debate, such that the community might not be able to arrive at a final product. So, the IBA guidelines are quite good. They're in almost universal use. This might be kind of the ideal outcome and the ideal framework we have. I'm not convinced that anything else might be necessary or even desirable.
Understood. Thank you so much. Mark?
I think, as you implied, as Craig implied, that the gap, the failure to regulate issue conflicts is not inadvertent. There is a significant controversy in the arbitration community whether it is appropriate to require anything at all about issues. And the reason for that is we all have opinions. Sometimes we put them in writing or say them at a conference. Other times we hold them inside our head. But they're still there. They don't go away. Suggesting that because I put something in writing or I said something at a conference, that I have therefore created a conflict strikes me as unusual. And whenever I think about the issue conflicts topic, I always come back to the question, we do not impose any issue conflicts duty on judges in national courts in most countries. Why are we imposing a stricter obligation on arbitrators? That strikes me as very confusing. And for me, that comes up every time there's a nomination for a US Supreme Court justice, and we all know that the nomination was based on the predispositions and articles and decisions that were written by that prospective nominee. And no one says they're disqualified by virtue of having had that opinion. They tend to vote on partisan grounds as to whether they're going to get the position. And the same thing applies for judges who have rendered decisions in public about an issue and then see a similar issue in a future case. No one would ever think that we should disqualify that judge because he or she opined on a similar topic or even an identical topic in an earlier case. It's an issue. They dealt with it. We don't think of it as a conflict in national judicial systems. Why in heck should we think of it as a conflict in the world of international arbitration? That's my strong and non-empirical opinion.
Thank you. Amanda, any thoughts?
Just very briefly, based on what Mark said, I think that's why I would favor treating any potential issue conflicts within the broader framework of independence and impartiality. I think if there is a potential issue conflict, it should rise to the level to show that there is, under an objective standard, reasonable grounds to doubt that arbitrator's impartiality in a particular case. And that should go beyond just having decided on an issue that will also come up in that case.
Understood. Thank you so much. Well, that's all that we have for this panel. Before we wrap up, just a quick reminder, the Washington Foreign Law Society puts on webinars and events like these on a monthly basis. You can check out our website, www.wfls.org, and sign up for our mailing list. It's absolutely free, and we promise we won't spam you. Well, the last thing was a lie. But if you've missed any part of today's discussion because you got distracted, don't worry. This panel was recorded and will be on YouTube very soon, so you'll have plenty of time to catch up. In conclusion, a huge thank you to our fantastic panelists for joining us, and to all of you in the audience for tuning in from all over the world. Thank you so much.
Thank you. Thank you all.
you.
Bye.